People really don't know what their expenses will be because they don't know how long that they're going to live.
Americans are worried they won't have enough saved for retirement now more than ever.
Retirement is going to cost, for many folks, over $1 million.
Is no sure thing in investing, but a lot of people think that annuities may come close to that.
It's going to more safe things that they know. If they know they're going to need that money to supplement their retirement, well, then you can't play that risk.
This is the Safe Money and Retirement Show with Jon Heischman Sr., founder and partner of Heischman Financial Services, serving the Columbus and surrounding areas. Jon specializes in educating pre-retirees and retirees about safe money strategies and ideas. Now, it's the Safe Money and Retirement Show. Here's Jon Heischman Sr.
Welcome to my show this morning. This is Jon Heischman, your host. Each week at this time, I bring to you ideas and concepts that will help you with your planning, whether you're getting ready to retire or if you're currently retired. My ideas and recommendations are going to help. So stay tuned for this morning's show. Before I get started, I want to give you the number to call because many of you are going to request information that I discussed this morning or one of the book offers that are available to you at no cost and no obligation. The number is 888-426-0177. Again, that's 888-426-0177. Write that down. I look forward to hearing from you as well as your feedback. I want to start the show this morning on a very important part of each retiree's planning. When we talk about your plans, your estate, believe it or not, it is very common that beneficiary designations are not set up correctly. The beneficiary form is probably the single most important document in the estate plan. A common mistake made by many retirees' plan is that owners of these plans have outdated or improper designated beneficiaries. You would think that choosing who will inherit your money or money left in your IRA, your 401k, would be simple. But the reality is many children and grandchildren who inherit qualified plan money, they're going to be forced into a rapid distribution, causing rapid taxation due to the beneficiary mistakes. So I want to talk about a couple of these mistakes, as well as outdated beneficiary designations due to one of the spouses passing or a divorce situation. It's very common when I sit down with a new potential client and we get to the point where we talk about inheritance, planning their retirement, their estate, beneficiary designations, they're outdated. Changes in their past created the need to make beneficiary changes, especially when we're talking about younger beneficiaries such as children or grandchildren, because younger or even less experienced beneficiaries sometimes can inherit too much too fast. In such cases, the inherited money can actually do more harm than good. If the beneficiary has limited experience in handling money or has a spendthrift problem, they can squander the funds that were intended to support them throughout their lifetime. I will say what I've seen is those who save money are usually better equipped to handle money than those who inherit money. So let's face it, the world holds many temptations, and often beneficiaries will quickly burn through their share of an inheritance. It's estimated that the average inheritance in the United States is spent within 90 days to 17 months. It's not at all uncommon to see diligent savers to imagine a big chunk of their savings winding up on the tables in Las Vegas or possibly the showroom of a car dealership. Now, there's different views on this. Some people are not that concerned. If that's how they want to spend their money, then so be it. Others are very concerned and want to designate more control because of a particular situation. So I want to talk about a simple planning tool that can prevent this from occurring. Individual retirement account owners can choose to restrict a beneficiary rather than allowing them the option of receiving a fully taxable lump sum distribution. And this is important because the majority of inherited money that goes to beneficiaries is qualified money because that's where most people have the majority of their money, from IRA accounts, from 401k accounts, pension, 403bs. We have a tax problem here with those type of accounts. In other words, the IRA owner can specify how the money will be paid to a particular beneficiary. Now, many custodians of retirement funds offer beneficiary documents that allow the owner to choose what they call a payout period. These payout periods can range from 5 to 10 years. And in some cases, it might be necessary to use a trust if your custodian doesn't offer the option of restricting a beneficiary, or let's say you desire more control over when and how your beneficiaries can access the funds. Now, when I talk about a custodian, that's going to be the company where your money is. That's where you designate beneficiaries. You have an IRA account. Maybe it's with an insurance company. You have a brokerage account. Bank accounts. They all need to have beneficiary designations. I always want to find that out. When I'm gathering the information from a potential client, I want to see the statements, and that is a perfect time to automatically go into the beneficiary designations. How is the beneficiary listed on each one of your accounts? I can tell you where I see the majority of outdated beneficiary designations is when I talk to an individual that has not had an annual review for a long time, or they're not working with a planner, or maybe they have what I call a house account. Their advisor retired, left the profession, and now their account was turned over to corporate or home office. And if you need something, call the 1-800 number. Time goes on, situations change, and before you know it, the beneficiary designations are outdated, and it does potentially cause a huge problem. So before I go any further, I want you to think about that within the next couple of days. How is your account set up? Is it through a will, through a trust, or just a named beneficiary? And your situation might need to have some changes made. And depending on how detailed and how many people are involved, there could very well be a situation where you need a trust. As a radio listener, one of the things I want to do is offer my help to work with you on your beneficiary designations. If you're not sure or you think it needs to be changed, a simple system that I have can accomplish that. I do not charge for this service. There is no obligation. It's something that I want to do to be able to help, especially for my radio listeners. Give me a call, 888-426-0177, 888-426-0177. And the other thing I can help you with is to determine whether or not you have a contingency plan. And that's because it is common for those that have IRA and 401k accounts that are the owners to name their spouse as the sole beneficiary of their qualified accounts. As a matter of fact, some states and some custodians will require the spouse's consent to name anyone other than the spouse. Naming a contingent beneficiary is equally as important as your primary beneficiary when we're doing effective estate planning. If both the IRA owner and the inheriting spouse are gone, who is going to receive the balance left in these accounts? I'm going to continue on this topic after the break, so stay tuned. I'll be right back.
Thanks for listening to the Safe Money and Retirement Show with Jon Heischman. For more information, call 1-888-426-0177. That's 1-888-426-0177. Or visit their website at HeischmanFS.com. More of the Safe Money and Retirement Show in a moment.
Avoiding mistakes can save owners of IRAs, 401ks, and TSP plans, as well as other retirement plans, a fortune in taxes, penalties, fees, and loads. These potential mistakes are addressed in the free book entitled Top 10 IRA Mistakes. This is Jon Heischman from the Safe Money and Retirement Show, offering a complimentary copy by calling 888-426-0177. Again, that's 888-426-0177.
Welcome back to the Safe Money and Retirement Show with Jon Heischman. To contact Jon, the number to call is 1-888-426-0177. That's 1-888-426-0177. Once again, here's Jon Heischman.
Welcome back to the Safe Money and Retirement Show. Thanks for listening this morning. There was a good article from Business Week Investor. They made the statement, it's a little known fact that individual retirement accounts, 401ks, and other tax-deferred plans are not governed by wills or state inheritance laws. Instead, the disposition of your retirement funds depend on two things: the fine print in your bank or fund company's custodial agreement and those little tiny lines where you listed the beneficiaries. So, if the IRA owner fails to designate contingent beneficiaries, the account balance may wind up in probate. Probate can be lengthy and very expensive, and during probate, those funds are locked down. And you've probably heard stories from friends or relatives where this situation has happened. Their accounts are tied up in probate because of improper beneficiary designations and how they are listed. So I want to go one step further and talk about how difficult and detailed this can be. And many times I'm going to consult with my attorney to make sure these beneficiary designations are set up. There are 4 options to consider if you choose to leave all or some of your IRA to a qualified charity. So choosing the wrong option can cause big problems for your other non-charity beneficiaries. And it's more common today to see what we call a split beneficiary on accounts where part goes to a charity and the other part goes to individuals. Also, name the beneficiary as 100% if the account is an IRA. Another problem area is when the account is split into 2 different IRAs. What about a charitable remainder trust as your beneficiary, or using a will to name your beneficiaries? These are all potential problem areas if they're not done correctly. And of course, we can't forget not keeping your beneficiary documents up to date, which I talked about earlier. Failure to update beneficiary documents is most common, especially when we're talking about an IRA account where there needs to be a beneficiary. And again, circumstances change. And when they do, your beneficiary forms will need to be revised. If you're in a situation where not keeping your beneficiary forms up to date very possibly can result in a disaster. Here are a few of the triggering events that should alert you that you need to get a beneficiary checkup. It's not uncommon for an ex-spouse to get an unexpected and pleasant surprise when the IRA owner dies. Why is this? Because the IRA owner failed to change the beneficiary document. In this case, a new spouse or the IRA owner's children could be disinherited. Couple of things that are important. A beneficiary that's designated that is passed or a new potential beneficiary is born. Either way, it's time for a beneficiary checkup. A beneficiary becomes disabled or incompetent and will not be able to manage their inheritance. You may need to consider a trust for the benefit of that beneficiary. What about one of your beneficiaries is financially well off, or a beneficiary becomes financially indigent? You may want to adjust the percentages to accommodate a real-life situation so you can best provide for loved ones who need financial assistance the most. Qualified money such as IRA accounts, the beneficiary designation can get tricky here. There's 2 sides to the story. Should the beneficiary be an individual or should it be a trust? What are the advantages and disadvantages of both? It always boils down to what is best for the individual, and we have to take taxes into consideration. We have a situation that could fall under what we call a spendthrift problem. You may want to restrict the compulsive shopper so they can't receive all of their inheritance at once. You could dictate that they will receive their portion over, let's say, 10 years. But keep in mind that a lump sum distribution from an IRA to a beneficiary also means immediate taxation. And this becomes a big payday for the IRS. In order to avoid that, a named beneficiary, especially in a spouse situation, they now have the ability to take over that IRA in their own name to avoid taxation. A lot of people want this situation to occur. Others possibly don't. And you've got to know your situation and get those beneficiaries listed correctly. The safest way to make sure your IRAs go to the beneficiaries of your choice is to have your beneficiary forms reviewed annually or when a triggering event occurs. As I mentioned earlier in the show, checking and reviewing the beneficiary designations needs to be reviewed. And the best time to do that is when you have a meeting with your planner, which should be yearly, addressing this with all accounts. Now, I know many of you listening could be thinking, well, I don't have an advisor or I haven't talked to him for years. Here is a problem that I don't want you to have to be involved with. So your beneficiary checkup can be addressed by using a simple planning form that is part of my review each year that I can assist in making sure the beneficiary designations are the way you want it to be. 888-426-0177. Again, 888-426-0177. And I want you to keep in mind that the beneficiary form is probably the single most important document in an estate plan. It trumps everything, regardless of what a will, trust, divorce decree, or any other signed document might say. So here's some things to think about. And if you want a copy of this, call the number I give and I'll have it sent out to you. Do you have a copy of each beneficiary designation for each account? Does it match the copy the custodian has for you on file? Does it address all situations of death? Are there multiple primary or contingent beneficiaries? Does it automatically establish a separate account? And does it allow for the restriction of a beneficiary? Does it redirect the IRA proceeds if your beneficiary predeceases you? Or does it address beneficiaries under the age of 18? And is it up to date? For example, if it's been a year or longer since the last time you had your beneficiary forms reviewed, it's time to revisit them now. A beneficiary checkup is going to help you determine whether your beneficiary documents are up to date and will accomplish what you want done with your accounts as far as qualified IRA accounts or 401ks, for example, and non-qualified accounts. This simple service will ensure that your family will not have to endure any delay and expense of probate. And that the balance of your IRAs and other accounts will go to your intended heirs. This is one more aspect of proper planning. Address the issue now to prevent potential big problems in the future. I've come to the end of my show this morning, and as always, I really hope it's giving you something to think about. And if you have questions or concerns, I'm here to help. It's not going to cost you anything to obtain my advice or to receive any of the information that I talk about on my shows. I'll give you the number one more time, 888-426-0177, 888-426-0177. Have a great week. I'll talk to you next week at the same time.
The Safe Money and Retirement Show with Jon Heischman Sr. To get in touch with Jon, call 1-888-426-0177. That's 1-888-426-0177. For more information about Heischman Financial Services, visit their website, HeischmanFS.com. That's HeischmanFS.com. Join us again next time for the Safe Money and Retirement Show with Jon Heischman Sr.